Good morning. I have the honor to sit here with former prosecutor Arne Stevns. My name is Elna Søndergaard and I work as a lawyer for DIGNITY-Danish Institute Against Torture. We would like to provide you with an insight into the Danish system regarding the use of pretrial detention. Therefore, I will be asking some questions to Arne, and we hope that our contribution will help in your training in Jordan. So greetings to all you Jordanian judges and prosecutors from Denmark, and we hope that you're all doing well. Arne, my first question to you would be, could you kindly explain the situation in Denmark from the moment when someone is arrested by the police?
Okay, if the police arrest a person, it's because he is suspected of a crime that is under public prosecution. The police can do it if there's a risk that he will abscond or repeat the crime or get in contact with accomplices or other persons involved. When the police arrest a person, they have to inform him, first of all, that he has the right to have a lawyer, and that lawyer can be paid by the state to begin with anyway, and he has the right to get in contact with his family, and he has the right to see a doctor of his own choice. The police can, after the arrest, keep the person for up to 24 hours if that is necessary. Before the 24 hours are gone, they either have to release him or to ask the prosecutor to take him into court and have a court decision of his detention. If the prosecutor look at the case and find that the conditions for detaining the person are present, and the conditions are the following: that he is suspected of a crime that can give more than 1.5 years in prison, that there is a reason, that there's specific reasons that he will abscond, specific reasons that he will repeat the crime, or specific reasons that he will destroy evidence. The third or fourth reason is that it's necessary because of the consideration of public order. In that case, it's a condition that there are strong specific reasons to suspect the person of having committed a crime. Normally that would mean that there are none of the other reasons present, but he has committed a very serious crime like murder, terrorism, rape, and so on. And that means that the crime has to be so serious that it can include more than 6 years imprisonment, or if it's a violent case, more than 2 months of imprisonment. So that is the consideration of the prosecutor. Can I convince the judge in the court that these conditions are present? Then I will call the court and ask for a court meeting, and I will get a lawyer. It's obligatory to always have a lawyer for the defense present at the court meeting. The lawyer has a right, in that case, to have an interview with the suspect and to look at all the documents that are provided by the police before the court meeting. During the court meeting, you will, of course, question the suspect, and the judge will, after hearing the case, determine if he agrees with the prosecutor that the conditions for detaining the person are present. If so, then he has to write down in his ruling exactly what are the specific reasons why you think that he will abscond. It's not necessary, it's not enough to say that there's a risk he will abscond. You will have to say there's a risk that he will abscond because he doesn't have an address in Denmark, and there's a reason to think that he will escape justice in that case, and another reason for that he will repeat a crime, which often happens, is that it's a well-known burglar who has been convicted before, and you catch him again in flagrancy, and you can see that he has been he has also made other burglaries, and then in that case it is necessary, the judge deems that he is detained. Or the last one, the risk that he will destroy evidence. For instance, if it's a drug case, then you know that there are persons, accomplices, who have not been arrested yet, and you don't want him to warn the persons or hide the profits or whatever, and you have to write down in the ruling all these specific reasons. When that is done, then you have to decide for how long time he should be detained. And he can be detained for up to 4 months. And then it can be prolonged up to 6 months if it's a case that does not include more than 6 years imprisonment, and up to a year if it includes more than 6 months imprisonment, 6 years imprisonment, sorry.
Thank you very much. That was a very clear explanation. And as I hear you say, in Denmark, it's an individual decision, an individual determination in each case whether the suspect should be detained or not. And the decision is made by the judge.
Yes.
Could you explain what would be the duration of the detention, and how would the judge assess whether it's legal to extend the pretrial detention?
Well, first of all, when he makes his decision, for instance, in cases where there is a risk that the suspect will destroy the evidence, then the police has to explain to the judge exactly what kinds of evidence it's necessary to collect, what kind of what witnesses are necessary to interview, and that will be in the ruling exactly what is going to happen during the 4 weeks if the person is detained for 4 weeks. Then after 4 weeks, the police can ask for a prolongation of the detention, but then they have to explain to the judge what has been done during the 4 weeks. Have you finished all the things that you plan to do? And why is it necessary to extend the detention?
Yeah.
And one of the reasons that the police could explain is that we have not finished our investigation, or we are afraid that the person in question, the suspect, will try to influence some of the witnesses that we have interviewed already, or that we have not found all the loot, and it's necessary to have more time to look for it.
Yeah. Thank you very much. So what you are saying is that after the first decision about detention made by the judge, then the police cannot sort of just sit on the case and do nothing, and then go to court again and ask for an extension of the detention. The investigation has to be pursued, and specific investigation steps need to be taken.
Yes, and that's examined each time by the judge if the police are doing what they said they were going to do. And if they have not done it, then you will ask for an explanation. Sometimes it's very difficult, especially if it's necessary to collect evidence in foreign countries. That can take quite some time, and you never know how long time it will take. So that's one of the reasons why the police will ask for prolongation, is that it's very difficult to obtain the evidence.
Yeah, I think that's very a clear explanation of the initial steps and the decision by the judge to detain. Could you kindly, Arne, explain to our Jordanian audience what happens in the case where the judge is not convinced that there are evidence to justify the detention?
Then he has two possibilities. He can either release the person, and then the prosecution can appeal that decision. And if the prosecution appeal the decision, he can uphold the arrest until the Court of Appeals has decided. Or he can release immediately. The other possibility he has is, if he thinks that there's a possibility that the conditions for detention are might be present if the police collect some further evidence, then they can detain a person for up to 3 days.
I see.
And then the police, after the 3 days, have to decide whether they think there are reasons to believe that the judge will detain the person in the normal way, so to speak.
Yeah, that's clear. So what you're saying is that there could be a situation that after only 24 hours, the judge is not satisfied with the reason being present for the detention, so he asks for another 3 days so that the police can take further investigation steps to collect the evidence.
Yes, and then you have a new court meeting if the police wants the detention prolonged.
Yeah, that's very clear. I have a couple of other questions, if you don't mind. So, in terms of the role of the defense lawyer, you have explained your role as a prosecutor, the role of the judge, and the role of the defense lawyer. Are you saying that according to Danish law, the defense lawyer can question the reasons given by the prosecutors to detain the suspect? And how would the defense lawyer fulfill his role?
Well, first of all, of course, the prosecutor will present the case to the court and make an interview of the suspect. After that, the lawyer for defense will interview his clients. And based on these two interviews, either the prosecutor will argue that the reasons for detention are present, and of course the defense lawyer will challenge that. He will say there's not enough reason to suspect, there's not a reason to think that the person will abscond, and there's no reason to think that he will repeat the crime. He is now becoming a good citizen and has learned his lessons. He will not commit any more crime, and so on and so forth. And it will be very bad for his situation. He will lose his job if he's detained, and it's not a proportional to look at the crime and look at the situation of his job possibilities, his family life, and so on. So it's unreasonable, even though you might think that he is reasonably suspected, then it's not proportional to the damage that will happen to his family life and his job situation. That will be the normal arguments, and then after those two parties have been heard by the judge, he'll make his decision. Then the lawyer will control that the ruling is very specific, so he can decide whether he wants his client should appeal the case to the Court of Appeals. And that's one of the reasons it's very important that the ruling is specific concerning which conditions are fulfilled.
Yeah.
That's the only way that the lawyer for defense can decide whether he should appeal the case or not.
Yes, thank you very much. As a lawyer, I can see that a condition for fulfilling the role as a defense lawyer is exactly that the decision to detain is justified and the evidence for the decision are present. Could I ask you an additional question? So could the defense lawyer, if he or she decides to appeal the decision by the judge, could he ask for compensation if he claims that the detention was unlawful?
No, first after there's a final decision concerning whether the person is convicted or not convicted of a crime. If the person is not convicted of a crime, he can demand compensation for his financial loss and for the suffering and loss of esteem that he has suffered.
Thank you very much, Arne, for these very pertinent answers. I have a last question to you. Maybe you have some final recommendations to the Jordanian prosecutors and judges in terms of how to use the regulations about pretrial detention.
I think in the Jordanian context, and I've been visiting Jordan several times and talked with my colleagues and I think one of the most important things is that the role of the lawyer. The role of the lawyer is essential in a fair trial process. And the lawyer should be present from the very beginning. That means from the time of arrest. In Denmark we have it, as I mentioned, that the suspect should be informed that his right to have a lawyer, and these rights are delivered to the suspect in a written form and in a language that he can understand. And it has to be written in the police report that he has been handed over this written information about the right to have a lawyer. I think that's very important for two reasons. First of all, the question of fair trial, and second of all, in being sure that no torture is used against the suspect. The other recommendation I could have is that it should be the rule that, and very important rule that is, that all the rulings of the court should be very specific concerning what concrete circumstances makes it necessary to detain the suspect.
Yes.
That is necessary because otherwise it's impossible for the suspect and his lawyer to decide whether there are reasons to appeal the case to a higher court.
Thank you very much. That was extremely interesting to hear you explain the Danish system and how each of the three parties, the defense lawyer, the prosecutor and the judge, each play a role to ensure that pretrial detention is used legally and not arbitrary. So I thank you very much, and we hope that we will have the chance together to visit Jordan again in the future. And we wish you all the best with the training at the Judicial Institute.